right. Good afternoon, everyone. Thank you for coming. Welcome to this workshop. I am from the Arts Arbitration and Mediation Services, a program of California Lawyers for the Arts, one of many of our programs. I am the program director of AAMS, as we call it, here in the San Francisco Bay Area. And today we're going to be talking about some recent changes to the Mediation Confidentiality law and how it affects you as practitioners, as clients, as mediators, whatever your role may be. So about me a little bit, I discovered mediation in law school, and I basically never looked back. I started mediating in law school through a clinical program, and I've worked at nonprofits ever since. I've done hundreds of mediations. I've been trained as mediator, arbitrator, facilitation, all different aspects of dispute resolution. And I love doing trainings, workshops such as these. So I've trained many mediators in dispute resolution, and even gotten to do some practical trainings, training mediators hands-on doing the work in the real world. I would also like to say a little bit about our organization. California Lawyers for the Arts is an organization that's been around over 40 years now, serving artists, and we kind of tried to tailor the mediation program to meet their needs, because artists have a little bit more unique needs than the average mediation client. They often go into business matters without thinking of the business part, or there's often lacking contracts and things like that, and there's lots of reputational and emotional aspects, so we found our program is really well suited to helping artists. We also have some other programs, a lawyer referral service, where people can call in from all over the state and artists can seek an attorney. And there are also arts and corrections programs. We do youth internships at arts organizations, so we do many things. And we also have membership benefits. So if you join a member, you get discounts on trainings and things like that, and lots of wonderful things, so please sign up. So I said a little bit about our program, but what we mostly do is mediation. A small portion is arbitration, but majority of the cases we do are mediation cases, so clients seeking to resolve things outside of court. And typical client is an artist who's often low income. Typical case might be we've had someone using my photograph without permission, or me and my co-writer on this play can't agree about who's going to get what writing credits or title credits or producer or director. So there's that type of issue as well. There's someone want their artwork returned, or maybe they have a damage to their artwork. Who's going to cover that kind of thing? Is the gallery, are they? Many different kinds of things, but we aren't limited to just arts issues. We also serve artists who have non-arts issues. So example, artist couple who's getting divorced and maybe they need some help figuring out how they're going to separate property. So we don't turn anyone away. We're happy to help anyone, but we typically do get more arts clients. If you're ready, we can dive into the confidentiality law, unless you have any other questions about our program or organization. So mediation confidentiality is very strong in the state of California, probably one of the strongest, I think the strongest in the United States. It is very important because we want to encourage people to try to resolve things in good faith. We want them to sit in that mediation session and really be honest about what the situation is and what they want out of it and what their goals are and how they might resolve that. So I really believe that having strong mediation confidentiality can protect that process and really help people to engage in it fully and give you the best shot at coming to a resolution that everyone is going to be happy with. Mediation laws have been on the books for several decades, and there's been plenty of case law and whatnot that's grown up around this world. But recently, the last few years, there's been a big conversation about the concern of malpractice suits and what about attorneys committing malpractice within the mediation context. And because everything that happens within mediation is confidential, even leading up to mediation, clients who are saying their attorney has committed malpractice within that process are not allowed to bring in any of those actions. It's all protected. All that is inadmissible. So the question was, how do we balance that, the need to protect clients from malpractice, because we don't want an attorney to be able to commit malpractice and then just say, hey, it's all covered by mediation confidentiality, sorry, you can't do anything. So balance the need to protect clients against malpractice, against keeping these strong mediation confidentiality laws. So to the end of this concern, the California Law Revision Commission, it's a body that gives proposals, and they're often enacted exactly as they propose, came up with a proposal in 2017 that would carve out a new exception to mediation confidentiality. And it was going to allow evidence that is relevant to an allegation that an attorney has breached a professional requirement in the context of mediation or a mediation consultation. So it's going to carve out this new exception. To those of us in the mediation community, this new exception was pretty scary because many of us think, not all of us, that it kind of blows open the confidentiality. All you have to do is suggest malpractice, and now all this communications can be opened up and admissible. So there are a lot of people who were very vocal against this. Plaintiff and defendant bar groups both came out against this new proposal, which is very rare for them to be in agreement about anything. Many, many mediators wrote many, many letters. A colleague of mine, Ron Kelly, if maybe you know him, he's a very strong proponent of mediation confidentiality. He helped write the laws. He also was very vocal against it and working with the legislature. And they came up with sort of a compromise. So this Law Revision Commission proposal has not been enacted, but it's still there. But it has not been enacted, and instead we have this compromise, this new law change as of January 2019. The new evidence code section is already section 1129 of the evidence code. And you have a handout there that has the full text of section 1129, and there's a small change to another one of the sections just to reference that. The gist of it, I'll give you a little summary, is that to a client participating in mediation, as soon as reasonably possible, before that client agrees to participate, they must be provided with a printed disclosure form. And this form must be signed by the client stating that they have read and they understand the new confidentiality provisions. This form has to be separate, printed up, not attached to anything else, in the preferred language of the client. So that's the gist of it. What that really means is that there's no change to the law, is what it really means. The law is still the same. The change is that the clients now have to say, I understand the law. So it's informed consent. We're requiring informed consent of clients to mediation. Informed written consent, yes, specifically. It is not a waiver of your rights to sue an attorney. You can still sue your attorney for malpractice. It doesn't change any of that. It is essentially saying, I wrote myself up a good little tip here. I had a good summary. So the legislature is saying it is scandalous that clients cannot sue their attorneys for malpractice using mediation communications. We think it's scandalous. So we're going to be for sure that the clients know this. We are going to make sure they know this and understand this. That's my layman's terms for you. I thought that was a good summary. So this is a compromise, I think, because it's letting us keep our strong protections, which I think is really important. And it keeps mediation that safe place for people to discuss everything freely. It allows you to talk about your weaknesses and not worry about them coming back to haunt you later in court. And I think it's also good to protect clients from malpractice. I'm in agreement that that's a good thing to want to protect as well. I think mediation confidentiality should be given very high weight, and it overrides some other considerations sometimes, and we're always finding a balance between those things. So some things to notice about it is that it requires this to be on a printed separate sheet in the client's language signed. I've heard some attorneys be concerned, well, I don't print anything out anymore. I do everything electronically. Everything's getting DocuSigned. But it says printed. Physical sheet of paper. The preferred language requirement, I think, might be a challenge because I don't know how to translate this into other languages. I don't speak them. The Judicial Council does forms in different languages, I think, but only 4, I believe. So where are all these different preferred languages going to come from when you have clients who English is not their first language? So it doesn't seem that we have copies of them in other languages that are just readily available for other people right now. But this is the law as it is right now. So what you see, what they're talking about in the new code section, there is a section with kind of this language that you can use as a template if you want to make sure that you have completed this requirement under the law. You don't have to use this as long as you are getting everything in there that you're supposed to be. This is just in there as a default. You might not want to use it though because it actually says in here about malpractice, like it uses the word malpractice. Maybe you don't want to be alerting your client to like, if I commit malpractice, you can sue me, as just kind of a triggering language perhaps that might not be desirable to some attorneys. But this is in there for your use, and I think it's nice they provided something that you can make sure you're complying with the law. But it's not required for you to use this exact language or exact form. So the question is, if there's a translator there and they read the English copy and they sign something and certify that they've read it and the person signs it, is that enough? I don't know for sure. The way that it is stated in the new law, I would say no. Because the way it's in here is printed in their preferred language. I mean, that seems pretty clear. I would say that's a ripe area for judicial interpretation in the future to come up. There's not really any assistance for us. If I had a client that had another language, I would try to get it translated, find someone to translate it for me into their preferred language so I could meet that. There's a distinction here between the attorney and mediator role. I'll talk about that a little later. Yes. Then that gets me to responsibilities. That's a good segue. Thank you. So, in my opinion, the burden is falling on the attorneys here because it is requiring attorneys to get informed consent from their clients. So it's on the attorneys to do this. However, I think that the true burden practically is going to fall more on mediators because we want to make sure that the attorneys know this new law and are following it. There's so much out there changing in the law constantly. I've talked to some other mediators who already are doing cases and they've brought it up kind of as a courtesy, like, hey, have you heard about 1189 yet? And they didn't know anything about it. So I think practically it's on us as mediators to just bring it up. I think that's a nice way to do it as kind of a courtesy. Hey, have you heard about this? You're required for your client to provide informed written consent. Here's the code section, check it out. I'd encourage you to get that done as soon as possible. I think that comes as kind of a kind thing to do without giving them the tisk tisk, have you followed the new law? I mean, it seems more, I think, a friendly way to support the attorneys in any cases that you have as a mediator. There is not any guidance on that yet. It's basically up to you as the mediator. If you know that has or has not been done, do you want to proceed? Do you want to bring that up to the attorney? I would encourage all mediators to bring it up. If it were me, I would bring it up early in the case to the attorneys to make sure that they're doing that. If they're choosing not to, then that's up to you if you want to proceed without it, or if you want to bring it up yourself. But I think all those are kind of tricky questions, and it might affect the relationships with the parties or the attorney and the mediation and how it could proceed. I've heard from some other mediator colleagues of mine that they're just carrying around with them copies of this form, and if the attorneys don't know about it or haven't brought it up, then they can just have it right then and there. So I think it's kind of a preference at this point because this is new. We're still figuring this out. There hasn't been a lot of interpretation on it so far. Yes, I think there is going to be a learning curve here for a while. That's why I wanted to do this presentation and to get the word out there and to let more people know. And please, you spread the word too, because I think that's going to help implement this as best as possible. Sure, and I think that could indeed be a hurdle. It's common that people are hesitant to mediate in a day of court situation. I used to do those as well. And just one more thing they have to do is kind of one more excuse for them to say, no thanks, I'm going to pass. But this is the new law that we have, for better or for worse. It is here, and we have to learn how to put this into our process as mediators. So that's a good question. That's something else to talk about, the consequences. So I'll get to that. But there's, I think, important before that is this is not a reason to set aside agreements. I want to say that up front because I think that's a really important part of it. If you fail to do this, doesn't mean automatically your settlement agreement gets thrown out, which I think is very key because we don't want people using this as a tool to get out of settlement agreements when they're having regret later. It's not an automatic into getting malpractice, so, right, per se. The way it's phrased is that the consequences to this, the teeth, if it is, for attorneys, is state bar discipline. So I'm assuming if, this happens and it gets reported to the bar and there's proof that attorneys are failing to do this, they could use it more as like building evidence, like, oh, if this attorney keeps doing this, we might, discipline them. I don't think there's been an indication from the bar yet how they're going to handle that exactly. I don't think it would be automatic discipline, like you're not going to get disbarred the first time. I think they'd probably keep them as like a course of conduct to kind of judge the behavior. That's possible. I think an unscrupulous attorney could definitely blame the mediator. I would also argue it's your job as attorney to be aware of the law and the requirements under it. And this burden does fall on the attorney under the law. That's the way it is phrased and it's worded. It's just my opinion that practically speaking, the burden is also on the mediators to be helping make sure this is happening. Sure. Because I want to have a good mediation process that is open and transparent, and I want everyone to have informed consent. But yes, I think that's a total possibility. Included in your materials as part of your process when you're explaining it to new clients to include. I think that also falls under this kind of courtesy method that I'm calling it, to encourage people to just, hey, this is out there, you might not know about it yet. We just want to make sure you're taking care of everything before you get into the mediation. So it's as soon as reasonably possible. So as soon as you're talking about mediation with a client, I'd say that's the time to bring this up. If they're agreeing to mediation, there is some language in there for cases where clients are already engaged in mediation and then the attorney's coming on later because they can't do it before. So that's when the as soon as reasonably possible language comes in, because you might not have been able to do it before they agree to mediation. So it's understood certain types of cases, it contemplates the existence of that. But as soon as the topic of mediation comes up, if I were an attorney, I would say, I need you to understand what the confidentiality laws are and what that means. Before you agree to this, here's the form, as part of the greater discussion that you would have with your client about mediation. I think that's a decision for each attorney to make on their own. If you put it in the fee agreement, at least you're getting it out there early and kind of taking care of everything that happens in the beginning. We just got to make sure it's on its own separate sheet of paper, not stapled to anything else, right? And I know clients are already looking at a ton of paper, and so I think it's to keep it from really getting lost, making it its own thing for people to make sure they're signing a million things and skip right over it. Something else that might be considered is that there's assuredly going to be challenges in court as time goes along, as things come up, as people start to put this into action, and as malpractice cases are going to come up and people are wanting to use the communications. So there's been decisions in the California Supreme Court that mediations are not admissible. So we have precedent for that. It's been upheld in the past, but that could change. I have here the Cassell case was the last one, if you want to look that up. I also brought or hand out to you, I did a summary of the Law Review Commission's proposal here. It's really, really long. If you want to look it up, you can find it online. But I just did a summary of like what their conclusion was and the main features of it. I would encourage you, if you have the time and interest, to go look at it in full. I think it's pretty draconian and serious, and I would really like it to not be implemented. I think the important thing is for us as a community to start making sure people are indeed doing this. Because if people aren't following through on this and clients are still complaining of malpractice, this proposal is still out there and could still be implemented at a later date. It's kind of just sitting in the wings, and the legislature could say, hey, the compromise isn't working, now we're going to implement this. And it would be a really big blow to mediation protections of confidentiality in the state. So I find that a little scary, not to like doomsday, scenario anyone, but I really believe in protecting the process. I've had so many good outcomes because people were really able to be honest. So please, everyone, do this. Make sure your colleagues and friends and loved ones are using this as well. Okay, other questions? No, as far as I can tell, no, there's not any real consequence. There's no real teeth written into the law that puts any burden or effect on the mediators themselves. It's really written for the attorneys. So no, I don't think it's going to affect them. It's just written as your client. I've had a discussion with other community mediation organizations such as ours, and the consensus is we think it doesn't require us to act either, although we think we want to bring it up if we know there are attorney-represented parties. And so each organization, just like each attorney, is deciding, do we want to have like a copy of that form ready to go to send them if need be? Correct, yes. If no one is represented by an attorney, no one has to sign this informed consent, because if you don't have an attorney representing you, you can't sue them for malpractice. Correct. Yeah, it's only in represented cases. Yeah, so your day of court mediations, depending which type those are, small claims, you're not going to have any attorneys there. It's not going to come up. If it's unlawful detainer or civil harassment, then yeah, you're probably going to have attorneys there and this is going to come up. But hopefully attorneys are discussing it as it's coming out. Yeah, I think in bigger firms who are probably, subscribe to services about new changes in the law, that kind of thing, they're going to know about it. It might come up within the firm, but smaller firms or solo practitioners, probably less likely to know. That's a good question. I haven't heard that one yet. Well, the way that it's written is when your client agrees to mediation, you're supposed to get the informed consent. But that's kind of that's an interesting question. If the court is kind of forcing them or sending them, is it the same scenario where they're agreeing? If I'm representing someone in that case, I would still go forward just to cover myself, I think, if I were the attorney. That's kind of, yeah, I think that's another gray area that isn't really addressed or answered. That's another great point. If you have an attorney but they're not with you in that mediation, does this still apply to them? I don't see any guidance in the laws to that scenario. I've definitely had mediations where someone wanted to step out and call their attorney. Does this apply there? Yes, if someone is represented by an attorney and they're going to agree to mediation, I would bring this up. Hey, have you heard of this new Section 1129? Just want to make sure I have a form I can send you. If not, I trust you can also find it on your own. I definitely am going to bring it up, as it hasn't actually, I don't think we've actually had attorney represented mediation yet this year. I'm assuming letterhead is okay. That's not really indicated. As I mentioned, that is just kind of the safe harbor language, so it's in there for you to use and it's not required. So I'm assuming it's there so that you can put it on your own letterhead and use it as you wish, just to make sure that's being done whatever way it's being done. A good practice tip is to maybe for mediators, if you have a case, well, I don't know if all of you this applies to, but if you have a case where there's like an insurance company and a client, someone's represented by an insurance, there's usually like a carrier. You might want to have both the client and the carrier sign this form, because they're both on that same side. Who's the real client there? That would be a good tip, I think, if you're engaging in insurance cases. Yes, buyer's remorse is specifically why 129E is in there. So this is not a reason to set aside, because we want to avoid that. I think that is one of the concerns with the Law Revision Commission proposal too, that it does open it up to people just using it as a tool to set aside just because they have buyer's remorse. No. A mediator is still incompetent to testify, correct. Thank you very much. Thank you so much.
Thank you very much for watching. If you would like to see more videos by California Lawyers for the Arts, please like and subscribe to CLA's YouTube channel so we can provide full-service live streaming programs soon. Our channel will be producing videos that cover all kinds of artistic, entertainment, and intellectual property legal issues. You can also find our videos on Facebook and livestream.com.